Hello, my name is Michael DeSaro, and I prepared this video case note on the recent New South Wales Court of Appeal decision in Nitopi. And I found it an interesting case because it discusses a number of High Court cases and identifies some inconsistencies in the decisions in relation to unconscionability and equity. Bit of background about myself. I'm a competition and consumer lawyer. I've been running my own practice, DeSaro Legal Consulting, for the last 14 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the NSWCA for 15 years in a variety of roles, including as Director of Enforcement. Now, the outline of the presentation, I'll start with some background, then look at the first instance decision, and then talk about the Court of Appeal decision, primarily the two lead judgments by Chief Justice Bell and President Ward, and then I'll finish with a bit of commentary. Now, the background to the case was Edigio Nitopi was a very successful businessman who'd run a number of successful ventures, and he amassed a lot of personal wealth. And when he died in 2014, he actually had an estate worth in excess of $21 million, which he left to his 3 children. Prior to his death, he'd also had a number of medical problems, including short-term memory deficits. He was diagnosed with alcoholic dementia, as well as chronic myeloid leukemia. So he'd been very unwell prior to his passing. And what had occurred is the estate had been administered and the money had been distributed to the beneficiaries, about $6 million each. And then it was discovered that between 2009 in July to June 2010, a number of payments had been made by Edigio to his daughter in relation to a venture she was undertaking, which was to establish a new fashion brand. And there were 6 payments totaling $1.2 million made to the daughter during that period. And the allegation was that the daughter engaged in unconscionable conduct by taking advantage of her father's special disability to obtain those funds. Now, at the first instance, it was concluded that at the time of the impugned payments, the father had lacked a sufficient level of memory to recall the previous requests by the daughter for money. So he could remember the previous times the daughter had asked for money for her fashion label. It was also found that he lacked sufficient degree of independence to decide whether or not to accede to the latest request for money. The court also found that the daughter was on notice that there were concerns about the deceased mental state, so she knew that her father had a vulnerable mental state, and it was not necessary for there to have actually, or there to have been actual knowledge of the full extent of the father's disabilities. The court also found that the daughter could not have failed to have seen the signs of her father's vulnerability, and that she ought to have known of her father's special disability, and finally that the daughter had exerted moral pressure on her father, who was not in a position to protect his own interests. Now, there were 4 issues on appeal. The first was whether the primary judge had made a mistake in basing the decision on constructive notice, and that being a sufficient requirement to engage the principle against unconscionable dealing. Secondly, whether the primary judge incorrectly referred to and applied this equitable presumption that applies in relation to unconscionable conduct in equity. And that relates to where there's an improvident transaction being engaged in by the weaker party. The third issue was whether it was a requirement or an essential element of the course of action that it be shown that the stronger party had engaged in conduct in a predatory fashion or with a predatory state of mind. And then finally, whether the primary judge had erred in finding that the daughter had exerted moral pressure on her father. Now, the decision on issue number 1 starts with a review of the Kakavas case, a High Court case, which involved a problem gambler who basically claimed that Crown Casino was aware of his addiction to gambling and yet encouraged him to continue gambling in their establishment, with the result that he lost a lot of money. And the High Court in that particular case concluded that the requisite knowledge for a claim of unconscionable conduct was either actual knowledge or willful ignorance amounting to actual knowledge. So that would be a situation where the stronger party is being given lots of indications that a particular person is suffering from a special disadvantage, and they simply turn a blind eye to those indicators. However, what was clear from Kakavas is that constructive knowledge was not sufficient to establish a claim of unconscionable conduct in equity. Now, Ward notes that there are two High Court decisions which are more recent than Kakavas, which seem to signal a move away from the requirement in Kakavas of actual knowledge or willful ignorance, and they are Thorne and Kennedy and Stubbings and Jams. And she notes that these cases seem to have accepted that constructive knowledge would be sufficient to establish unconscionable conduct in equity. Now, she notes the plurality decision in Stubbings of Keane and Gleeson, where they say that the defendant should have known particular relevant matters. They also considered that a sufficient or lively appreciation of vulnerability was sufficient. So that's all very supportive of there being a requirement of constructive knowledge as opposed to actual knowledge. And they also noted the decision of Mason in Amadio, which they adopted and endorsed, where there was reference to what the defendant ought to know, which is again constructive knowledge, not actual knowledge. Chief Justice Bell also noted the Thorne and Stubbings cases, and he notes that they appear to represent something of retreat from Kakavas's apparent insistence on actual knowledge or willful ignorance. And there, in relation to the Thorne case, he notes the plurality in that particular case had commented that it is also generally necessary that the other party knew or ought to have known of the existence and effect of the special disadvantage. So as you can see, the words ought to have known there are clearly indicating constructive knowledge. And then the plurality in Stubbings had said quite clearly a finding of actual knowledge was not essential to the appellant's case for relief. So they'd made it very clear that constructive knowledge would have been sufficient for the appellant to win in that particular case. So the question is, what are you going to do if Kakavas requires constructive knowledge? And what Ward concluded was, it's clear from the Stubbings case that the plurality had endorsed the statement of Mason from Amadio, which clearly adopted the language of constructive knowledge in relation to unconscionable dealing cases. And that constructive knowledge had to extend to both the existence of the disabling condition, or the special disadvantage, and the effect of that special disadvantage on the innocent party. And that were the same views expressed by Stewart in that case, where he noted that constructive knowledge had to extend to the existence and effect of the special disadvantage. So she was satisfied that constructive knowledge was sufficient to establish unconscionable conduct in equity. Now, the view of Bell was a little bit different. He commented that the only way to possibly reconcile Kakavas and Thorne and Stubbings as well in relation to questions of knowledge was to understand Kakavas as standing for the negative proposition that constructive notice was insufficient to establish unconscionable dealing in equity, but not standing for the proposition that constructive knowledge was insufficient. So he would, I guess, read down Kakavas to limit its application to cases of constructive notice and not to cases of constructive knowledge, which is somewhat difficult given the clear language of Kakavas, which states that constructive knowledge will not be sufficient. Now, in the particular case before the court, it was clear on the evidence that the appellant did not have actual or constructive knowledge in relation to the father's special disadvantage at the time of the majority of transactions. So there was a number of transactions that clearly she didn't have actual or constructive knowledge. Accordingly, the appellant was successful in those claims. In relation to the final claim, which was for a relatively small amount, what the court found was that at that particular time, the father did not have capacity to enter that transaction, so that was void. So effectively, the appellant won on the first argument that she didn't possess actual or constructive knowledge of the father's special disability. Now, the second issue related to this equitable presumption and whether the judge had applied it correctly. And the way this works is if you are able to prove special disadvantage and a knowledge of the special disadvantage, then the court will actually look at the nature of the transaction. And they may conclude if there is an improvident transaction or a transaction that really doesn't benefit the weaker party in any way and is not a financially reasonable or sensible transaction for them to enter into, that the evidentiary onus will shift to the stronger party to show that the transaction was fair, just and reasonable. So it's important to understand that the court will actually look at the nature of the transaction, and if it appears to be a very improvident commercially problematic transaction for the weaker party to enter into, then it will force the stronger party to put evidence forward that it was fair, just and reasonable. So in the present case, that might have been that the father was a big supporter of the daughter's business, the fashion business, and giving her money for that business was a fair, just and reasonable expenditure. It wasn't necessarily an improvident transaction. In this particular regard, the court held that the primary judge had not made any mistakes in the way that he had applied this particular equitable presumption in this case. Now, the third issue was whether there was an essential element of the cause of action, that it be shown that there was some sort of predatory conduct or conduct had been engaged in a predatory fashion or a predatory state of mind. And this idea of a predatory conduct comes out of Kakavas as well. And the way Ward approaches it is she notes that the statement of predatory state of mind is really just another way of saying that there needs to be unconscientious exploitation with the requisite knowledge. It doesn't import anything additional. It's just a way of describing particular conduct that occurs. And so she's saying that if you can establish that there is a deliberate or intentional taking advantage of the known special disadvantage or disability, then you will succeed in establishing unconscionable conduct. So obviously the three elements are that there is a special disadvantage, that there's actual constructive knowledge of that special disadvantage, and that the stronger party has taken deliberate or intentionally taken advantage of that special disadvantage or disability, and that could be inferred from the improvidence of the transaction. Now, they also noted some other circumstances where the predatory intent could be shown, and Ward notes that the mere knowledge of special disadvantage or disability is not enough for there to have been unconscientious exploitation. There has to be something more. And she thought that if there was a situation where the stronger party had passively accepted or attained benefit, that could be sufficient to satisfy this requirement of predatory conduct and predatory intent. Then Bell also expressed a view, and he put this as being a provisional view, that the predatory state of mind could be established and presumed to have been established if a gift was made by a person who was clearly suffering from a special disadvantage, and further, that the recipient of the gift had actual knowledge of the special disadvantage. So slightly problematic, the use of actual knowledge in that particular formulation there, but showing that the predatory state could be achieved if those two requirements were met. The final issue that was considered was whether the trial judge had made errors in relation to the moral pressure point. And the view of Ward was that the reference to moral pressure was clearly the judge describing the requirements of unconscionable conduct in equity, wasn't necessarily importing any new consideration. It was really just a way of describing the vulnerability of the deceased. So she didn't think that the use of the word moral pressure established any error on the part of the primary judge. Justice Bell probably had a different view. He looked at it more in terms of fairness. He was concerned that the idea of moral pressure and emotional pressure had sort of been raised in the hearing at the last moment. It hadn't been set out in the pleadings and hadn't actually been foreshadowed in the opening argument. So it was more or less sprung on the appellants in the course of the hearing. He thought that was a problem, and had the other issues not gone the way they'd gone, I think he may have found an error by the judge in allowing the matter to go forward in the way it did. Now, the disposition of the case, the appeal was allowed in part, so most of the transactions were found to be valid and not subject to the product of unconscionable dealing. One transaction was voided due to the fact that it was proven that the father didn't have capacity at that relevant time, and there was a requirement to repay money to the appellant as a result of the decision. There's quite a lot of money there. There's obviously a lot of interest as well. Now, the commentary on the case, I think the first thing is that there clearly is some inconsistency in High Court decisions about the knowledge requirement in unconscionable conduct. There's no doubt that Kakavas says that constructive knowledge is not sufficient to establish unconscionable conduct in equity, and the other case of Stubbings and Thorne go the other way. So it's important, I think, that the issue needs to be looked again by the High Court and clarified, because what's actually occurring is there are a number of courts around the country which are following Kakavas and are dismissing claims that are based on constructive knowledge. And in their judgment, there's reference to a number of cases, particularly in West Australia, where Kakavas has been applied and cases have been knocked out. So what you're seeing meritorious cases which probably should get across the line based on constructive knowledge not succeeding because of the conflict between Kakavas, Stubbings and Thorne. The third judge in this particular case was White, and he seemed to think it was all a bit of a storm in a teacup. He didn't think that necessarily there was that much of a problem in his reading of the particular cases, and he didn't think it was necessary for the rest of the court to go down this path of exploring these issues. I don't think his position is really tenable. I think if you look at the cases, there is definitely a problem, and the sooner it's brought to light and the sooner the High Court picks up a case and resolves this issue, the better. So I don't think his so-called, it's not a really dissent, but his view I don't think was the right view. So I think it's important that the elements of unconscionable conduct be clarified. I think this case is helpful in the guidance it provides on a number of elements, including the equitable presumption, the shift to the onus of proof, and also some of the other issues in relation to predatory intent. But clearly the key issue here is what is the knowledge expected or required to establish unconscionable conduct in equity. So hopefully that's been clear. I think these cases can be quite complicated, and this judgment is somewhat complicated to fully comprehend. So if you have any questions about this presentation, feel free to give us a call or drop me an email. Bye-bye.